Okay, today is Monday, May the 2nd, 2022. And of course, you know my name, Professor Richard Wright. And I'm doing this a little early to record it for you so that you will be able to have it because I'm going to be doing something to celebrate my pre-birthday. We started celebrating it yesterday, May 1st, at our church. My wife surprised me with a party at the church after worship service. And then actually the worship service was a celebration. And so I was ecstatic and received some nice gifts and so forth. So it was nice time. So I'll be doing it tonight. And then, of course, tomorrow be a bittersweet day, celebrating uh, the memorial service from my mother who passed away March 16th. And that'll be also celebrating my 72nd birthday. So, um, so tomorrow I won't be on at all. So I'm getting all my lectures taken care of today and getting you guys started. So, because this evening I got some things I'm going to be doing that. So let's go ahead and get started. Before I share my screen, let me say this to you. And this is so important. And I guess I could share my screen to show it to you. I had a number of you to send me messages wanting to know why you got the grades that you got. And so what I want to show you is something that's very important. And this is why I say over and over, you got to be very careful. Each of these scenarios, what you're required to do is, of course, develop a 3 to 4 page paper and support your rationale with appropriate case law. You see that there? Appropriate case law. And I already told you how to officially cite the case with the number first, US, and then there's a number, and then parentheses, the year. And you're supposed to do this APA. Many of you did APA, but you didn't cite the appropriate case law. Now let me show you what that did for you as far as the rubric, because I always tell you, pay close attention to the rubric. Now, this rubric, if you look at it, it actually has something in here. Okay, let's say you didn't provide case law. So you wouldn't fit in this category. You wouldn't fit in this category. You wouldn't fit in this category. But you have to go to this category. It says missing rationale support with appropriate case law. So the rubric, which is a good thing because it provides instructions and directions that you must follow. Notice all the way down for each scenario, it says the same exact thing. So then what people did was they got in the 55 and then, no credible sources. Okay, if you did provide credible sources, then you might have gotten this one. But for each scenario, you still got 55 because of the fact that there's no case law. And then if you fell short of the 3-page, which only a few of you did that, then you fell in here. So that is what I wanted to point out. Students said, I missed that. I says that's because you didn't pay close attention to the rubric. It's in there. It's clearly in there, and it's in the module. And I also talked about it during the lecture. So what am I saying is you can be careless. And then some students ask, could they submit it again? And I says, I'm sorry, I can't do that because that would be open it up for everybody to do that. I can't do that. That's why I take a lot of time to make sure I cover the requirements of the assignment. Very important. And that's why I said uh, don't rush through. Do a good job getting the assignments done, and you will maximize your grade. All right. So now let's look at, okay, there's messages. I'm not going to go there. Of course, the grade book. And we look at where we are for week number. Okay, I got to grade the written assignments for everybody who submitted them. So far, I got 19, but by the end of the week, I will have had those graded for week 4. Discussion posts, I'll be doing those in the next couple of days, not tomorrow though. And then here we are. Written assignment is Sixth Amendment trial rights. Again, I'm going to talk to you about that and take some time and go over the rubric. The 5th module discussion is right to an attorney. And then your live classroom submission, which is due by Sunday. Okay, notice this. Here's something that a lot of people get messed up by. It says discussion, initial post due. It doesn't say, it just says this is due by the 7th. Well, the 7th is Saturday. But if you look at the calendar, this is only the reply post. The calendar and the announcements and what I point out during the lecture requires your initial post for this week to be submitted not by the 7th, which is a Saturday, but your initial posts are Tuesday, since the beginning of this course, and it will end the same way during the last week. So bring that to your attention. And if you go over to the calendar, which we will do right now, you'll see the month view. We are now in May. Your lecture is tonight, but I'm doing it now. Your initial post, there it is, right there. Every week it's been like that. Tuesday. Then we will do another live lecture on Thursday. That is for week 6, because the course will end on the 10th, which is a week from tomorrow. Okay? And be aware that your grades, your final grades, will be submitted by the end of the 13th. So next week is a busy week for me as well, because the new classes start the 11th, which means that I will be doing a lecture on the 11th and the 12th for the 2 classes. I do know what the classes are: drugs and crime, and also constitutional law. So the constitutional law lectures will be starting on the 11th. That's for the new course, not this course that we're in now. All right. And those of you who don't pass, and I think I only got 1 or 2 students who are not doing that. All right, so that's our calendar. So you should be pretty clear on that. All right. Let's go back to, I didn't mean to click that. Let's look at the discussion. Let's look at the announcement. So this is week 5 announcement. I will post on Wednesday the week 6 announcement. In the 5th week, the 6th Amendment and government authority will be presented, and I'll cover that. I sent you previously the PowerPoints for chapters 10 and 11 of the textbook, and we're going to discuss the 5th Amendment, obtaining information legally, the 6th Amendment right to counsel and a fair trial, the scope of the right to counsel, the concept of speedy trial, and Sixth Amendment rights, and then there's a knowledge check. One of the key cases, Miranda versus Arizona, which we will be talking about, the right to a speedy trial, and then right to counsel, research starter, and speedy trial, research starter. And then reminding you again that the lecture is taking place now. It was scheduled for 7. And then the discussion assignment. Here we go. The right to an attorney. Initial post Tuesday. Reply post Saturday. So the 3rd for the initial post, the 7th for the reply post. Can't put any more clearer than that. The written assignment and the key phrase will be due on Sunday, and that is the Sixth Amendment and trial rights. All right, and we'll talk about that and pay attention to what is in the module under the lessons tab, as well as the rubric, and then what I say. So let's finish strong, and you know my motto, adversity is the springboard to success. All right. So now let's get right into the week 5 module. So let's talk about the written assignment. Okay, now it's telling you here, you're going to create a 1 to 2 page training flyer about the Sixth Amendment and rights related to counsel, speedy trials, and the basic rights that take place in the trial. So in a 1 to 2 page flyer, explain the right to counsel and how it applies to those suspected of criminal behavior. Discuss speedy trial requirements and common time frames from arrest, initial appearance, all the way to trial. We'll talk about those. Explain the role of the criminal complaint and indictment or information file. What is the purpose of that? What does it do? Discuss valid reasons for the confrontation clause. You know, the confrontation clause allows you to respond to the charges that are against you. Analyze the scope of the permitted media access to trials. Cite credible sources in APA format. You know what that means. At the end of the 1 to 2 page flyer. Now, listen to me good. Hear me what I'm about to say, please. Please hear me. It's not a contradiction. I want credible sources throughout your paper. I keep saying this all the time, regardless of what you might read here. Those who don't listen to the lecture and try to do it without that, I can tell because that's what they do. Identify the state you're using, as well as the rules, citing the statutes, rules, cases. Use professional language, spelling, and punctuation. Okay? It is going to be in a Word document. Did you hear me? In a Word document. Please submit it as a Word document. Very important. All right. Now let's look at the rubric. So give me a citation in the body and references at the end. Now, if you do not provide citations and you just provide references, it falls under incomplete or incorrect explanation. Okay? If you cite a case, you know how to cite it. And you're not going to be able to provide. There's some leading cases that we will be talking about concerning the right to counsel, speedy trial. So if you don't have any credible sources, you're going to end up over here. I can't put you anywhere else but that. All the way with each of them. No credible sources are provided. Got to provide them. And then a minimum of 1 to 2 pages. If you don't have that, and if it's just a little bit on that page, it's not going to cover it. Don't be afraid to do 2. And make sure your spelling and grammar is correct. Remember, the cover page is important, properly formatted, as well as a reference page. I keep saying this over and over and over. So what are you going to do? You're going to follow everything that's said in this box to write to counsel. Cite your official court cases. Don't give me OAs or fine law. Outstanding discussion of the speedy trial requirements with citations of sources where you got that information. The criminal complaint, explain that. The confrontation clause, demonstrating a clear understanding of it. Outstanding analysis of the scope of permitted media access. And then credible sources. Once again, very important how you cite them appropriately, and it must meet the 1 to 2 page requirement. You got to follow the rubric. You've got to. Got to. Very important. Do not submit it to me in PDF. Do not submit it to me in Publisher. Do not submit it to me in PowerPoint, but as a Word document. Okay? Don't get hung up on credible sources in APA format at the end of the flyer. I want it throughout the flyer. But what they're referring to is a reference page. And I'm just clarifying it for you in my lecture, as well as how I use grading. And I've been doing this consistently since week 1. Okay? Any messages? I would suggest at this juncture that you text me or call me. You can send an email, but it might be, you're getting down near the end. Remember, next week the course ends. You don't want to do that. All right. Don't expect any responses from me tomorrow, though. Usually I respond right away, but don't expect a response on Tuesday. Wednesday is the earliest that I would be responding because I won't be on at all tomorrow. All right. And that's it for that assignment. Please follow the instructions. So the right to an attorney. So you're going to provide an initial post tomorrow using this scenario. You're going to discuss the rights to an attorney and when it applies, when it doesn't apply. Discuss how to handle the situations, like comments like, do you think I need an attorney, or should I get an attorney? Discuss what we call the 2-week rule. We'll talk about that in a few minutes. And support your position with case law. Remember, if you do, you know how to cite it. Okay, very important. All right. Again, that initial post is due tomorrow. And then your live classroom submission, you'll put that phrase in there and I will grade it. Then your link, of course, will be replaced by what you see here with the recording that we're doing right now. All right, and then I'll also email the same to you today. So let's talk about these various issues. The scope of the right to counsel. Right to counsel. Those are 2 that fit together, actually. And then the speedy trial. And then a summary of the 6th Amendment rights, and then do a knowledge check with you real quick. So let's talk about what the right to counsel is all about. As you know, the Sixth Amendment of the Constitution um, uh, makes it quite clear that, um, and I'm going to just go ahead and give me a second. Let me take it a second here. I'm going to actually read it for you. The Sixth Amendment says, in all criminal prosecutions, the accused shall have and enjoy the right to a speedy and public trial. The exception to that is juveniles, by an impartial jury. The exception to that is juveniles of the state and the district wherein the crime is committed, which district shall have been previously ascertained by law, and to be informed, you are to be informed of the nature and cause of the accusation. That's where the information or indictment comes in. To be confronted with the witnesses against you. That's part of the confrontation aspects clause. To have compulsory process to obtain witnesses in your favor. That means issuance of subpoenas. Subpoenas for the person, and then what we call a subpoena ducis tecum, which means not only do you come, but you bring the documents. And then assistance of counsel, the Sixth Amendment right, which we will point out to you very clearly. The leading case for that is Gideon versus Wainwright, W-A-I-N W-R-I-G-H-T. Gideon, G-I-D-E-O-N, versus Wainwright. All right. The citation for your information, which is not down below, is Gideon v. Wainwright, 372 U.S. 335. That's 372 U.S. 335. And in parentheses is 1963. Okay? And that is the official landmark case for the Sixth Amendment. Very important, okay, for you to be familiar with that case. All right. So you want to make sure you have that cited in your assignment. So here's the scenario here. It's a Friday evening and the court is not in session, and you arrest someone. The suspect is put in jail by 11 p.m. Friday. When must the law enforcement officer reports be completed? When does the suspect have to be brought in front of a judge? Must the suspect sit in jail over the weekend without judicial review? And we're going to discuss those issues. So be aware of case Miranda versus Arizona. And Miranda versus Arizona, I thought it was cited down here, but let me give it to you again. I gave it to you before, but Miranda versus Arizona, a 1966 case, is 384 U.S. 436. That's 384 U.S. 436. And of course, it's 1966. But everybody knows the Miranda warnings, the right to remain silent, and we're going to go over those. And it also reminds you of the right to an attorney. And so the right to remain silent, the right to an attorney. Listen to this. Just like the right to remain silent, the right to an attorney only applies when a person is in custody. That is, they have been formally arrested or what we call constructive arrest. You should be aware that what we mean by constructive arrest is what I previously discussed, but I'll mention it very simply by reminding you that it means that you're not free to go. Okay, your liberty has been taken away. And at that particular point, any questioning, which we previously discussed in last week, should cease without giving the Miranda warnings. Very, 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 very important. Okay? The right to an attorney, I already said, came from the Sixth Amendment. I read it to you. So now, when you're in custody, you have a right to an attorney. An attorney's right is so important that law enforcement officers should appreciate and understand it. Not just because it's part of the Miranda case, but it's also actually part of the amendment, the Sixth Amendment to the Constitution. Failing to properly recognize the right to an attorney can result in statements being suppressed. When we defense attorneys would file what we call motions to suppress, that is to have the evidence, no matter how good, how egregious, to be removed from the case and not be allowed to be brought up during the trial or else result in mistrial and the individual going free. The right to counsel is a right that the individual has and must be invoked by the suspect. Listen to me good. By the suspect, not by the suspect's mother or anybody else. Now, when we deal with minors, it's different. But we're talking about adults here, so let's stick with that. If you reinitiate the questioning, it doesn't matter. Come back and says, do you still want to do this? You still want to do that? Don't do that. The only way you can do it is if the suspect is sitting and asks for you to come and make sure that they did it voluntarily and decide they want to talk to you. At that point, then you want to give rights again. Okay? Now, a defendant can waive the right, or if 14 days have lapsed between questioning. 14 days. What is that? In other terms, 2 weeks between the questioning and the custody. So the Sixth Amendment is so important. And again, remember the leading case I gave you, Gideon versus Wainwright. Let's go on next. So the right to counsel, that's the scope I've given you. And you're going to see stuff in here that you already know. So this is just a review.
Do you think I need to? Is not similar to counsel. If this or similar inquiry is made, law enforcement should clarify the suspect if they are arresting an attorney. For the is made, it must be honored. Questions should be asked, or questioning should cease. The right can also be asserted after it is initially waived. For example, the suspect has waived their rights and agreed to answer questions, they may assert the rights anytime during the questionnaire. If a suspect requests an
I don't know why. I don't.
officers, the 10 suspects subjected to interrogation may have the right
Okay, I don't see the back button. I mean, the next one. But the whole thing in a nutshell is that what I've already talked about in terms of the right to counsel. And I will say this, that if you read this information, remember that the suspect has to not ask a question, but make the statement that they want counsel. Very important for you to remember. Okay? So you understand everything that was there mentioned about the case. And then Maryland versus Shazer changed that. And okay, I'm going to skip going over each of those. But what I want you to do is to go through each of these, and I want you to look at the cases themselves and listen to what it says. So go over that section because there's some things that you would not hear because I have my headset on. But read through each of those sections, note those cases, and remember the official court citation if you use them. All right. So if you go back to this, just trying to show you something, you see the official citations for those cases. There they are right there. All right. So let's talk now about speedy trial. One of the issues contained in the Sixth Amendment is the right to a speedy trial. And so recognizing that the Fifth Amendment to self-incrimination, the Sixth Amendment right to a speedy trial, and the 14th Amendment, which applies this to the states, provide what we call due process rights. So it allows individuals who are charged with crimes to be able to respond to the allegations and charges. And you have a series of hearings that take place. And two of the key factors is a speedy trial, which, by the way, speedy trial is pretty much determined on each state has its own. However, within the context of the Constitution, Sixth Amendment, speedy trial, and the Speedy Trial Act that I'm going to mention in the federal cases, that's the context that most states set up their speedy trial acts. Okay, so the key thing is that the public is allowed to come in during those trials. They are not to be closed off from the public. There are no trials except juvenile trials. Okay, and you see, it says, just paraphrasing this quote up here that I read already from the Sixth Amendment, and in all criminal prosecutions, the accused shall enjoy the right to a speedy trial and a public trial by an impartial jury. Also ask for a bench trial. All right. So what's the speedy trial? Well, the key thing is that it takes some time once an individual is arrested, and that an average of 9 to 13 months it takes from arrest to trial. If it gets to trial, let me point out to you that 10%, roughly 10% of the cases actually end up at trial. The other 90% generally are settled by what we call plea bargaining. And what causes the cases to take longer is the period of time that the attorneys exchange documents called discovery. And during that period of time, what happens is the speedy trial clock is stopped and started. And eventually, it is quite clear that the individual would have to have a trial. If the prosecution misses by 1 day the time period that they should have brought a person to trial, um, I mean, without any tolling or stopping of it, then the case cannot be tried because it'd be a violation of the Speedy Trial Act and the Sixth Amendment. So the Speedy Trial Act of 1974 came about and required that an indictment is filed within 30 days after a person is arrested. And the trial must commence, it says, within 70 days and not less than 30 days from the indictment date, requiring at least 30 days between indictment and trial. Now, once again, that period of time can be adjusted and changed by the prosecution, generally the defense. That's who really does it. Or either the parties can, by agreement, stop the clock, and it starts back up when they come back to court. So there are reasons for the speedy trial because it's important to make sure that people aren't held and incarcerated long while they're waiting trial. So let's assume that a person is incarcerated 6 months, and then the case goes to trial, and then they're found not guilty. Well, they've spent 6 months incarcerated, and they won't get any credit for it because it was dismissed, or either they were found not guilty. But let's go to the other side. If they were found guilty, what will happen is at the sentencing stage is that the individual will receive credit, what we call time served, already served. So those 6 months would count into determining whatever the final sentence. So let's say if the person is sentenced to 2 years, well, then that means that that actual service time initially would start out with 18 months. Okay. And so there shouldn't be unreasonable delays. Um, okay. A violation of speedy trial provision may result in cases being dismissed. Check the Dickey versus Florida case. And it explains that this man was in federal custody for seven years. Days before he committed bank robbery, he also robbed a gas station and was identified as a witness. So state law enforcement was aware of the federal imprisonment, but they didn't provide him with a trial date in Florida, saying that he was unavailable because he was in prison in other states. The Supreme Court said, no, that's your problem. They said Dickey should have been given his right to trial in the state. And the state charges were dismissed because they were waiting on the feds. Can't do that. Can't do that. Okay. In addition to ensuring a defendant's due process rights, such as providing a public hearing, the right to a jury or bench trial, including receiving information about the charges themselves relating to the items or things that the prosecution has to support their charges. Okay. So the arrest to trial time frame is, like I said again, it says there is no universally accepted number of days, but it's outlined in the Sixth Amendment normally begins at the time of arrest when a person is or when a person is formally charged. And so some jurisdictions have established rules. So in Wisconsin, an arrested and jailed person has to appear in front of a judge within 48 hours. And that's generally the rule, 2 days. So the answer to the question about that person being arrested over the weekend is that they can be brought before a magistrate within 2 days. A preliminary hearing to determine if there's probable cause to take the case to trial or to further charges within 10 days. And if the defendant remains jailed, or within 20 days if they're released. So the point of the matter is it's faster if the person is in custody. Okay. So the key thing is that the speedy trial rights will be determined not just by the Speedy Trial Act, which we have here, and you can click on this and it will take you to what the Speedy Trial Act says. Now, this again is the federal. You'll discover that the state that you use will determine what specifics in terms of the amount of time that a person has. But the clock begins to tick right away, right away. Okay. So let's look at the Sixth Amendment Trial Act rights as we conclude here. I already read you what the Sixth Amendment says. And the key thing is that it says you're to be informed of the charges and to confront the witnesses so that you can question them about their veracity to be able to determine that they had the right person. And then subpoenas can be issued. All right. So it starts out with the complaint. Okay. And then the complaint is filed by the prosecution, and the complaint provides probable cause to believe that that person committed the crime. And remember, we talked about probable cause before, the proof needed for an arrest or either a search warrant, and is less than beyond a reasonable doubt that is required to convict. So a reasonable person should be able to look at the allegations and determine based on that that person probably is the person. But remember, you are presumed innocent until proven guilty, either by your own admission or by a trial by a judge or a jury. All right. Prosecutions rely on law enforcement to provide information in their reports. And if the prosecutor looks at the reports and don't believe probable cause exists, they might not charge the individual. If it does exist, then they will draft a criminal complaint and present a copy to the court and to the defendant. Same thing with a search warrant, two parts, the complaint and the affidavit, which we talked about already, list the charges, and the affidavit contains the facts about the case, determine whether probable cause exists. So the complaint is filed, and then there's some pretrial proceedings that take place. And as I said, generally it's within 48 hours after the person is arrested. Okay. The only exception to this rule is if the prosecution can demonstrate the existence of an emergency or extraordinary circumstances to hold a defendant. And it really is the burden of them. All right. So you look at Riverside versus McLaughlin for that. And then many jurisdictions provide some further elaboration on that in their own rules and statutes. So at the initial appearance, a judge does not make an official determination related to probable cause, but what takes place is that the individual is allowed to um, provide counsel and also um, request bail, reasonable bail, and then the next court appearance where what we call a preliminary hearing takes place. And so the probable cause will come later. All right. So in the process of the trials themselves and the hearings, the complaint is given, and there's the fundamental rights of the defendant to be provided with written documentation and three other reasons. Here they are: to ensure that the witnesses testify under oath and face the penalty for perjury for false testimony. Very serious. Allow the defendant to question witnesses who testify against them, and usually that's done through counsel, but periodically people represent themselves, but it's not a very good move. Allow jurors the ability to determine the credibility of witnesses by listening to the testimony of the individuals. And generally, the defendant, through their attorney, has the opportunity to question law enforcement and others. The order of questioning depends on whose witness is testifying. If the witness is testifying for the state, then they put their question first. And then the defense comes in what we call cross-examination and vice versa. Okay. There are some rules of evidence that are applicable, which we won't get into because they're more involved. There's a course that they used to offer on evidence. I used to love to teach that. And if it fit within some of the exceptions, then the evidence could be admitted. You've been in situations where you've heard questions being asked, and the other attorney will say objection, and then the judge will sustain it if they believe it's a general objection. But sometimes there are specific objections, and the judge will ask, what's your basis of your objection? So you have to be ready to provide the basis. Otherwise, your objection is overruled. If your objection is overruled, that means that the questioning along those lines can continue. If the objection is sustained, that means then the individual who's asking the questions cannot continue along that line of questions. And usually, if it's sustained, sometimes we'll ask that it be stricken from the record. Now, the funny part about that is that it could be stricken from the record, but it's still going to be in the record, but it's going to say that. But then the trier of fact, being the judge or the jury, has already heard it. And so uh, in the closing instructions, the judge usually gives the instruction to remind them to ignore those. But you know, that's not going to work in reality. Okay. At the preliminary hearing, or what we call a probable cause hearing, defendant can challenge the facts determined, and if the defendant prevails and the court that probable cause doesn't exist, the charges are dismissed. If the judge or magistrate determines probable cause, then it continues through the criminal court system. Okay. So here's a knowledge check that you can take time to go over, but I'm just going to just briefly show you. Then we're going to adjourn. Which statement is an example of a clear invocation of the right to an attorney? Maybe I need an attorney. I want an attorney. Do you think I need an attorney? I don't know. Should I get an attorney? I already provided information to you saying if it's a question, it doesn't satisfy. If the person says maybe, then they're not. But if they say I want, that's as clear as you can get and direct to the point. All right. Second one. This is the last one that I'll do. It says, what is the correct application of the 2-week rule? An in custody defendant warned to remain silent and cannot be interviewed again. An in custody defendant who has requested to remain silent cannot be interviewed again. An in custody defendant requesting attorney was released and interviewed again after a fresh Miranda warning. So what was the correct one? Was it 1, in custody warned to remain silent and cannot be interviewed again? An in custody defendant or an in custody requesting attorney was released and interviewed again? That's the answer. Applies only when an in custody defendant has requested an attorney. The request is honored and the law enforcement waited 2 weeks before attempting to interview again. A fresh Miranda statement must be done. So those are the things. So that is it that I have for today. So I need to give you a key phrase. The key phrase that I want to give you is one I talked about a whole bunch. Right to counsel. Give me that. And you get your points for the week 5. Right to counsel. All right, I'm going to say good afternoon to you. I'll see you again this Thursday, or this Friday, should I say, for the week 6 lecture. In the meantime, you know how to reach me. Remember that Tuesday, tomorrow, I will not be responding, but Wednesday, I can respond at the earliest. So good night, and get those assignments in according to the rubric and instructions that I mentioned. Pay close attention to the instructions I gave today for the assignment to complete for week 5.